If there's any help to be gotten at all in Collier County, you can get it through this group. So without further ado now, we'd be open to questions, and I'd like to moderate. That is to say, I will recognize you and pose your question, please.
No, I have an answer.
All right.
No, you asked I was thinking, you asked a question. For those of you, the homeowner association or property managers, if one of your borrowers, one of your owners doesn't pay the assessment, file the lien right away, because when their lender forecloses, they're going to serve you with the complaint. So you should answer it. And you can even do it yourself. Just get something on the record, because what might happen is what your question. Once they get the foreclosure judgment, if they don't go to sale and you're sitting there waiting for your assessment, if you're a party to the lawsuit, you could probably go in to the court and say, Judge, they're not setting the sale. We want the sale set because we want a date for when someone's going to take over. So for the property managers and the people who are in the homeowner associations, don't ignore a complaint. And a lot of lawyers will say there's nothing you can do. You're not going to get paid. You have to wait. But once you get on the record, you'll know exactly what's going on. So I tell everybody, just file an answer. You don't have to do anything else but file an answer.
Yes, ma'am.
I have a question. Condominium association. I'm on a board of directors, and we have one unit now that's in lis pendens. Owners obviously haven't paid their association fees for 2 quarters. We have filed a lien. My question is, if we take that to foreclosure, we're in second position.
Don't do that.
Don't.
No, when I was talking about the it doesn't make sense because you got a mortgage.
This is a little bit different. In this case, we're in second position.
It's not worth it.
If we were to go to foreclose, does it go to auction right away, or are we in a position where we have to pay off that first mortgage?
You'd have to pay off the first mortgage.
That's what I was afraid of.
So you know, it's not worth it for you to initiate the action, but if the lender does,
well, you wouldn't have to pay off the first mortgage, exactly. You could take title, and what I just read in the paper or one of the blogs recently, a case out of Orlando, where they took title on a short-term basis, rented month to month to try to create income for the association, and then the bank foreclosed against the association.
But the bank might actually allow that under certain circumstances.
Because there's possession and the property is being protected in that circumstance.
Well, yeah, but then, there's a lot of issues. You need to really talk to a lawyer in any of those cases because you got to look at what the equity is in the property. And there's a lot of issues, but in general, you don't.
There's no equity in this one.
Yeah, and that's the problem. There's no equity.
And there's other examples as well.
Yeah.
If the association moved quicker than the bank, foreclosed on their lien faster, yes, it's going to be subject to the first mortgage lender's lien position, but then the bank still has to come in afterwards and foreclose it. If they're looking at a 6 to 9 month process, maybe they can rent it out for the season and get some income to help pay with the association.
Well, how can you do that? They're still owned by the persons or person.
They would foreclose. But the problem is you're going to pay attorney's fees to do that.
The shortfall of that, though, too, is that you've now divested your own association away from its right to the 6 months prior assessments that it would otherwise get when the bank forecloses.
That's why you need to get a lawyer whenever you got something like that. But if it's just a straight deal where you filed a lien, you haven't done anything, and the lender files a foreclosure, just file an answer so you'll know exactly when there's a judgment. You'll know when there's a sale, and if they don't do a sale, then you can go hire a lawyer at that time. You can file your own answer. It's not a big deal.
Yes, ma'am.
I've heard of some new companies that are coming up to fill like a niche where they are guaranteeing the assessments, the monthly assessments to the condo association. And I'm not sure what happens. I'm assuming that the association assigns rights to go after people for things. Do you know anything about these companies?
Are you talking about a management company that comes in and they guarantee that the budget that they won't charge any more than this to operate the association?
No, they are guaranteeing payment of the assessment to the condo association, and then they are pursuing the owner.
Oh, then they are.
That's probably doing what he said, and then they take an assignment of the lien. I think
that's interesting.
Have a lawyer look at that. I mean, I'm not going to tell lawyers, but I think you should.
This gentleman.
But I would like to have someone on the panel please address the gray area between when a borrower abandons the property and the bank actually takes possession of the property in a foreclosure. What is a condo association's rights? They turn off the power. We've got common areas where mold can grow. We've got pest control gets to be a problem. What are the condo association's rights?
I'll take a stab at that.
Thank you very much, Brian.
The first thing I think you need to look at is your governing documents, and because a lot of times, whether it's a condominium or homeowners, it'll offer some set of guidance for you in terms of, whether or not you have the right of entry in that particular circumstance. And I can tell you, I've represented several condominium associations where the pool was left unkept, and they had issues with that, where mold, water intrusion was coming in, windows were busted out, and so they were having issues with respect to that. Depending on how you look at it, there usually is the right of entry for the condominium association to prevent damage to neighboring units and or the condominium association common property. So I would definitely look at your documents in terms of that. And in some instances, there's also specific language in your documents which allow you to charge that back to the actual unit owner. Now, what is that?
We don't have a unit owner. He has abandoned the property. The bank doesn't own it yet. We're in limbo. And that's what we need to know.
Unfortunately, in that circumstance, when your unit owner has abandoned and you can't find them, and even if you went after them, you probably would get a judgment that you couldn't collect on. Unfortunately, in that situation, the association, it kind of has to take the loss in terms of, you're in that decision of whether to act to protect the community, which I think an association should do, versus kind of letting it sit, wait for the bank to do. I've typically in the past written letters to banks, and this was kind of in the past when banks were a little bit more proactive in terms of keeping the property to sustain the value of the property itself, which puts them on notice that typically in their mortgage they have the right to enter the property prior to the foreclosure action being finalized to actually take affirmative steps to themselves take that burden on. Obviously, in today's world, they're not doing that in light of the inequity in the property. But I've taken that affirmative step to put them on notice that together with the association, you kind of both have a common interest in sustaining that property in order to you guys keep the value of the property within your community, and for them to keep the value of the property, knowing that they will eventually take title to the property. You're kind of limited. Someone else may have another suggestion, but those are typically the way I look at it.